questioning Mr. Barrett. You have 6 minutes. Go ahead, please.
Good morning. Do Canadians have a right to privacy?
Absolutely.
Can you give us examples of the software that's been used by the Government of Canada to spy on Canadians?
As I've described, these types of digital forensic tools are able to retrieve information from device, from computers, to see information that may have been deleted or not deleted. So they are able of obtaining information, including personal information, which is why in situations where they're used and directed towards individuals, whether it's employees or in other circumstances affecting their privacy, a privacy impact assessment should be done.
Okay. So can the software that the government is using unlock a locked smartphone?
In certain instances, my understanding is that they could.
Can it access password-protected laptops and iPads?
Again, my understanding is that it can, and these questions should be asked of the institutions as well.
The personal information that could be accessed, can you give us an idea of what the range of that personal information would include?
Well, personal information could be the data that's contained on this information, the files that are on that device, other types of use, whether something was deleted or not deleted, and so whether a website was accessed. And so these are tools that have important capabilities, and which is why in situations where they're being used to target individuals or to investigate individuals, this is the type where we would expect to see privacy impact assessments being conducted so that these things can be assessed and mitigated.
Photos, text messages, direct messages, search history, all accessible using these tools?
Our understanding is that they could be, absolutely.
Can the tools that are being employed by the government track the movement of Canadians?
Track the movement of Canadians?
Their physical location in real time, or their location, their physical history?
Typically, these types of devices will not be used remotely with the device not being in the possession of the investigator. So you would have that device in your possession, and that was one of the distinctions between those and the on-device, the audits or the spyware, where you can access the device with the individual not knowing that you have it and not being in the possession of the device.
So just let's be clear. The spyware being used can, once the device is in the possession of the government, can retrieve information, even deleted information, but there are remote capabilities as well, where software can be covertly installed and then used to track the location and the use of a device.
If we're talking about digital forensics tools, which is what we're talking about in this context, they can be used to acquire digital evidence, recover deleted files, analyze files of interest, create a timeline of interest and events. They almost always require the physical access to the device. So that's the distinction between what is spyware or audits, where you could do that remotely without the knowledge of the individuals. And so they're different tools, but they still nonetheless have important capabilities.
How many government departments have this capability?
I don't know of all the departments that would have it, but certainly from the reporting, there were 13 that were identified as having those tools, and so we've followed up with them and have obtained information.
So is the only way that you would be aware, or your office would be aware of the intention to use or the capability that a department had this capability, is if they were required, that government departments were each individually required to complete a PIA, a privacy impact assessment, in advance?
Well, in many cases, that's correct, because we don't know what a department is doing unless they advise us, unless they consult us. So the policy of the Treasury Board requires that, but it's not a legal obligation. And so my recommendation is it should be. It always is better for the department, for Canadians, for my office, when that proactive reach out is done from the department so that we can provide our input, we can flag risks, and Canadians can see that this is happening. Some of these tools can be used appropriately. There are good reasons for it, but we need that privacy check, we need that assessment.
Do you differentiate between the types of tools that government departments use when you consider something like the COVID app, where the government said that they wouldn't use the app to track the movement of Canadians, but that's exactly what they did. So it seems like the government, the attitude towards the privacy, the right to privacy that Canadians have, that attitude is lacking.
Well, I think that we have to strengthen that generally. There is more and more technology being used with greater capabilities, and that brings innovation, and that brings opportunities. But we need to have that reflex of privacy by design, privacy at the front end. Often we'll see the situation where the tool is developed, it's used, and then we do a privacy and impact assessment, or we bring in those things. It's always going to be more economical, more prudent to bring privacy at the front end. And it's more important than ever in this day and age where we have AI, where we have technology that is ever more capable. And so we really recommend that this be a legal obligation for that purpose.
Thank you, Mr. Barrett. Mr. Dufresne. Mr. Barrett, go ahead, please.
Can you explain to us the distinction between data or information that is stored on a device and information or data that is only accessible via the device in Canadian law? And the relevance of my question, or the precision that I'm looking for, is with the regular use of cloud-based storage, while the physical device might be the property of the Government of Canada or a government department. An individual who's logged into cloud-based storage of their information, the information isn't stored on the government's device, but is accessible via that device through the individual's personal login credentials. What's the difference in law?
Well, we would look at that as personal information about the individual will be personal information relating to them, and so whether it's on the device or whether it's on the cloud or whether it's in some other form, we look to see, is this information protected appropriately, and who is gaining access to this? Who has control over this information? Is it legitimate for the government to seize that information? What are the boundaries, and so on and so forth? So that we wouldn't draw too much of a distinction on that in terms of whether it's on the cloud or it's on the device. We would really look at what is the basis for obtaining it? What is the technology that you're using? What are the expectations that the individuals had? And so those would all be questions that we would ask in that context.
So there's no limit then to the reach of the government in using this technology in spying on Canadians. Cloud-based storage, Microsoft, lots of folks use Microsoft to store their documents. Dropbox, Google, all cloud-based. People store family photos in there. They store personal correspondence in there, confidential and private medical information into there. Would it ever be appropriate for the government to use the guise of, well, it's a government device, and you once logged into your cloud-based account using that device, therefore, we now have unfettered access to that? And is the only measure after the fact what they looked at and, we only took certain things? Once they viewed the information, the privacy of the employee has been violated. That Canadian's personal and private information has their privacy has been breached. Is it ever appropriate?
Well, there's a principle of limiting collection, and we all, again, link to that necessity and proportionality. If you're the employer and you're going to be looking at data of the employee, it's all part of the transparency. Make sure the employee is aware this is your work device, you're using it for personal things. Is there mix? What are the expectations in terms of what the employer will have access to? What does the employer need to have access to those things? So it's all about making sure that the employer or any other organization doesn't get to collect and use more information than they need. And so looking at the purpose, looking at the context, we gave the example of the truck drivers being filmed and on their personal time. That wasn't necessary for safety on the roads. So similar types of questions would be asked. The more you're going to go and get at my personal information, the more you should have to justify why that is. And that's what privacy impact assessments do, and that's what necessity and proportionality would do. And we live in a time where that technology, as you described, is more and more invasive, and sometimes there's a mix between the personal and the work life. And so that brings that raises privacy implications.
Would a PIA be used to approve the software or technology that the government plans to use, or is there a process in advance of collecting the information? Ought there not be a requirement for any government department to have the technology, that specific software, pre-approved? And this distinction about this is only it's just employees of the government of Canada. Well, they're a pretty big employer in this country, and their employees by and large are Canadians, and that's not to be glossed over. We seem to be playing catch up so often on privacy issues with government and government departments. Would your recommendation be that the software be approved even prior to procurement?
Well, I'll read you 4.22 of the policy on privacy protection from the Treasury Board, and it says, notifying the Privacy Commissioner of any planned initiatives, legislation, regulation, policies, programs that could relate to the Act or any of its provisions or that have an impact on the privacy of Canadians. This notification is to take place at a sufficiently early stage to permit the Commissioner to review and discuss the issue involved. So that same point, do it before, not after, so we can flag concerns.
Okay, thank you, Mr. Dufresne. Mr. Barrett?